Hey, welcome to Justice Served TV.
Yeah, hold on just a second. Michael Bryant, Linda Kenney Baden's assistant. I'm calling on the Aiden Carney matter in Atlantic City. No, it's not Baden. No, it's Linda Kenney Baden. Okay. All right. I'll hold. I guess I'm on hold. Hey, we got a couple things we're going to talk about. Among others, is perhaps some new representation for Turtleboy. Is that possible? I'm not sure. Hey, I'm looking at our gadgetry here, and it seems to be out of whack. Very curious.
Love you, Linda. Love you.
In the courthouse the other day, in the hallway, you're singing "Oh Happy Day."
From some beat through the night, victory, oh what a sight. Oh brave souls in the storm, raise your swords, no more to mourn. Giant hearts in battle form, legends forged and never torn.
All right. Why do I have the shirt on? I only wear this shirt.
Why are you
times.
stirring things up? We were stirring things up.
That was what happened today. Somebody thought I was your assistant, and I'm just following up on that.
I know. It's the greatest thing. You know, it's the greatest thing that somebody thought you're my assistant, because I can't tell you how many times that my husband gets called and says, and then someone says, "Have your assistant Kenney send it to me." Excuse me.
Yeah.
Have I only tried a few thousand million? Have I only
Just
been
no
in a
respect.
million cases? Have I only have a number of published opinions? Have I? Oh my God, I wouldn't even go through it. You can go to my CV on my Linda Kenney Baden website. That's an advertisement there, by the way.
I'm not sure I'm qualified to be your assistant. But anyway, I only wear this shirt when we're in Justice Watch, Verdict Watch, right? And the case we're going to talk about, because the closings were amazing in so many ways, the instructions and the things we've talked about leading up to this contributory negligence issue. This is the clock as I understand it now. They've not come back, as best I can tell. I'm not there with any questions or ending for the day. So I'm just going to let this run for now. So about 2.5 hours they've had the case. The closings began a little later than expected. What a shock. Court was not 100% on time as expected. But
I know, before we get to that, but I know it's on Fashion Friday, but I will say you are the only person I know that has a green lumberjack shirt. Okay.
Yes. Interesting. If you, I'm an Untuck It guy. This is an Untuck It, and I have no sponsorship with them.
Nantucket, or did you Nantucket?
No, Untuck It. This was genius. I like to tuck their shirts in because it's kind of a more casual way. So he designs a whole company which is blowing things up called Untuck It. In his commercial, and it started in San Francisco, I believe, he has this shirt on. I'd already bought it, but he has this on in the commercial. Anyway. I had a note here about what the rip and reads were today. hold on just a second.
As a matter of fact, I have the note about the rip and reads because I so many yesterday. Tonight's your turn. I'm going to be the commenter.
Yeah. Well, I guess the Aiden Carney matter is one of the rip and reads, and that is, and those who haven't seen the Mark Betterow note, this was the matter in Patterson, not Atlantic City. This is the matter that we've talked about and blew it up very early on, saying it was ridiculous, had to do with cyber harassment, cyber stalking. There's an obscenity component to that, which led us to believe this girl's nuts. That was my legal conclusion. This girl's nuts. And so that didn't survive the initial review by the prosecutor in New Jersey. As Linda knows, it goes to somebody to determine what level this case is. Because it's just here's my complaint. I just put it on this Post-it. Here you go. And they look it over and they decide whether it's something or not. They immediately dumped it from felony to misdemeanor. Today, it was dismissed in its entirety. Mark Betterow having yet another success in that.
And I tweeted that we had posted. We had Darren Gelber, a super uber lawyer from New Jersey. All his credentials are in. We did 2 episodes on this. Episode 1, you can go back and listen to it as to why. And people are telling us we don't know what we're talking about. No, we're only the New Jersey attorneys. We know what we're talking about. But in New Jersey, it's always a clue. I was a prosecutor in New Jersey. I ran a trial team, tried a death penalty case in New Jersey. Right. Let me tell you, when a complaint goes to the prosecutor's office, which is what we call our prosecutors, 21 counties, 21 prosecutors appointed by the governor of the state. And it's not signed by a police officer. It's not a police officer complaint that sends it up to the prosecutor's office to review. That's usually the first clue for the prosecutor that, okay, no police officer put their name to this. But anyhow, they will still treat it fairly and look at it fairly. And when you look at it fairly, they have to come back on the side of, and we told it right away, this case was getting dismissed.
It was garbage. And I do appreciate that regular folk can just do their own thing and try to get some sort of satisfaction through the process. But you got to go through a couple of hurdles. You can't just fill out the form and expect, where's my judgment against this person, or where's my conviction against this person? And so I do believe the right thing has occurred. And so Aidan Carney can take that one off his list. He's got a few of them. So I'm this morning, Aidan does his bus stop live thing every day. And it basically is something he's done since the day he was arrested, which I think was in October of 2 years ago. And it's just kind of a catch up with his folks, right? And so he was talking about not only what happened today, it had not happened yet, but what was going to come up. I thought it was the 12th, maybe next week, in Atlantic City. Now, I have a life, so I'm not up on every Aidan Carney problem and where they are and who they're involving and who's backstabbing whom. But that was new to me. And somebody listening said, somebody who had chatted in after he said Mark Betterow can't do that one. Yeah, he's got other stuff going on. Aidan needs somebody on retainer, full time, just to do his stuff. And so somebody said, get Linda Kenney Baden. And then, of course, Aidan said, Linda Baden. Yeah, that's yeah.
No one can pronounce my name right.
I know.
Anyway, it's Kennedy, it's Baden. As long as I win my cases, that's all I care about.
That's right. So
Helen Mirren knew how to pronounce my name when she won the Screen Actors Guild Award for playing me. So that's okay. I'm thrilled with that.
So anyway, I can't wait to see how that all falls out. I mean, comes together. So anyway, the other stuff. We have a couple of cases we've been following. Remember the Courtney Klenny case, which is the OnlyFans case out of Southern Florida, Miami. Her boyfriend, Mr. Obamseli, is stabbed. She says it was self-defense. They had a very contentious relationship. We had just started our kind of review of the case, getting ready for that December 1st trial date, right? In fact, it was on the Friday that we first laid out the groundwork. We had some body cam of some issues that took place literally 24 hours before this guy was stabbed and killed, right? And on that day, they pushed the trial. Right. So it's been pushed to the spring of 2026. And so what was going on today? Today, there was an attempt to get her out on bond while they're waiting for this pushed trial date, because she's been held without bond for almost, I think it's more than 2 years. I want to say it was mid-2022. Check me on that, guys. But they wanted to get her out. Changed circumstances might be that the pushing of the trial creates a greater hardship than initially thought. Don't know what happened in terms of their arguments, but I do know that nothing happened. She has not been released from jail. That, I believe, was taken under advisement or submission, depending on which state you live in.
Or bail or bond, depending on which state you live. For those of us who are in a bail state, I suppose bond state, words mean the same actually in terms of the practice, but they just use them differently.
Bonded out, bailed out, released, and none of those things have happened from what I can see. That it was a loss for her today. So that's one case. Then in the Brian, this is so aggravating to people. In the Brian Kohlberger case, which you may remember is over, he pled guilty to the death of those 4 University of Idaho students. Just horrific case. Nobody, and I mean globally, not a lot of people happy that it was cleaned up the way it was. We know all but one of the parents seemed to be okay with it ultimately. But what's he in court for today? What's going on today? That's a done deal, right? He's in there today asking to be relieved of the restitution part of the deal. I think it was something like $27 million. I mean, it was a lot of money. In the agreement, and if you listen to the judge, he really was not happy. He did not rule from the bench. I think he should have. He did not. Same judge.
And you know why he wasn't happy also about that? Because at the very end of his sentencing, this judge said, please, everybody, don't say his name. Don't bring him up in the media. Don't do anything. Let him go away. Let him live, the rest of his life inside those 4 cement walls. And yet here we are talking about it.
Yeah, and he's dressed up with a tie on. It's like seeing a snake, your favorite reptile,
Oh,
with
my.
a tie on, so there's dead eyes. Anyway, the judge is pissed off because the judge is really grilling this guy's attorney, saying, well, why did you enter into the plea agreement? Aren't you effectively saying you're going to violate the plea agreement? You're here to get me to ask to allow you to violate the plea agreement. Why would you agree to? I think it was 20,000 in the plea agreement. And so, not this giant number that they were trying to get relief from, but the judge said, well, what about the 20,000 that was in the plea agreement? Does he have that? Well, no, he doesn't have that. Well, then how did you enter into the plea agreement? That's in bad faith. So the judge was really grilling counsel about that. To me, that's an advisory opinion. Basically, the judge is just going to rubber stamp denied at some point. That's why I wish he would have ruled from the bench. It would have had a greater impact. But okay, he wants to.
And everybody who gets sent behind the bars, for the most part, can't file or comply with those restitution. But what happens is no one mentions them because they're never coming back out, and it just keeps building up and building up and building up. Of course, if you do get out, then of course you immediately have a violation of probation because you haven't paid the restitution.
Right, and I don't know how many times, probably on less than one hand, we could count how often that happens. And it always amuses me when they give somebody a life sentence or something that basically ends their life. And that's $522 in court fees, and it's like, okay, technically I get it, but really. So in this case, to I'm sure the satisfaction of everybody involved, the court looks inclined to deny this request to get out from under the restitution, which unfortunately is never likely.
And may add, I understand may add cost to it because apparently there's money that has to be restituted. No, I'm just kidding. I just made that word application. The money that has to be given, the funereal urns for some of the victims. All right. And they're around $500 some each. So I think that there's a look for at least maybe 4 or 5, 6 of them. I'm not quite sure. 6. Well, it can't be 6 urns because it's only 4 people, but 4 urns maybe at whatever they cost, or maybe it's 2 urns, or maybe it's 1 urn. I don't know. I was just kind of like I'm making it up because Brian Koberg was making it up, so I'm kind of making it up. My point is, I didn't make that up. That is something that the judge may add to the restitution.
Sure, and those are legitimate. In the big scheme of things, really, who cares? I mean, but the fact is, his actions caused those expenses. Who else should be responsible for them? Hold on, I need to reach over here and grab my brains here. Hold on just a second.
Okay, while you're grabbing your brains, let me just point out that Trust is Love. It became a YouTube member. Thank you, Trust is Love. I hope you enjoy. Michael Bryant had his first episode of the book club. Everyone's already buying the book, which he'll show you in a second. And we will have a second episode of The Hunt, the search for Stephanie Vilko. I'll be doing that for release Friday at 5 o'clock. And next week, the way I came to it is because I think this week was too early. We'll try to schedule it either next week or the week after, where I'm actually on live with all of you, and you can just come in and we can kind of like go over what we have and see where we're going next. But you can do that if you're a member. If you're not a member, you can't do that, and you'll get notice of it. Be a subscriber, okay? Yes, be a subscriber to Justice Served TV. It doesn't cost you anything to be a subscriber, and you may find it's a very wonderful community here. Our chats are very lively. And thank you to Madeira Beach Caregiver, $50 donation. Thank you so much. Recently, I was involved in an extremely important event, an honor walk. Oh, I'm going to cry already, for an organ donor patient I cared for. The greatest gift you can leave on this life is that in helping others' lives, be a hero, angel. No greater legacy can ever be made. At Madeira Beach, I even cried at the honor walk at the episode of The Pit. Okay. I even cried at that because if you haven't seen it or know about it, it's incredible. Everybody who knows you lines up with the body going out that's still on life support to save the organs for a new life, new donor, a new life. And I can't even talk about it. I don't know how you do the hospice work, Madeira Beach.
That is God's work, I'm telling you.
Yeah.
And for those who haven't even contemplated it, most states have on their DMV process where you can get a little organ donor stamp on your license, so that if, God forbid, something happens in an accident, there's no question about what you wanted to be done, and save some lives, even in the loss of your own. So follow a heart. Olivia Knight, hi Olivia, you're in our chat. We're going to talk about it a little bit today. Hi Olivia. Olivia's terrific. She's been so busy
She's been so busy. Olivia, we stay out of the drama because we just support you. You know, we support you, and you don't have to ask for our support because you are one heck of a person.
She's amazing.
Olivia's
Let me touch on this while you mentioned it. Since you plugged your hunt, let me replug this. It did launch just today for members, and I'm still trying to craft how to best do this. Maybe it's once a week live. We do go through a chapter. I'm still working it out. It'll be once a week something. And we'll figure it out. I'm thinking maybe midweek, like next Wednesday. We launched it today. Maybe next Wednesday. Maybe we go through a chapter. We'll figure it out. But this guy was amazing.
Justin read his own part of his book, right? Justin Brooks.
Justin Brooks. Right? Yeah, just amazing. And let me this remind me one quick story he told. The first chapter is called "You Hired the Wrong Lawyer." Okay, you take part in plea deals, right?
Right.
Here's a plea deal. This is what inspired him to get into all of this Innocence Project, wrongful conviction work. He gets a client in Illinois, somebody that just feels like she's gone through every possible avenue of relief, and somehow he learns about her friend of a friend. She's taken a plea deal. She's already in prison. She's taken a plea deal on a murder charge. So when that happens, what maybe would you work out of the deal? And in Illinois, by the way, death penalty state. What might you try to work out of that plea deal?
Getting rid of the death penalty be number uno.
No, not this attorney.
No,
not this attorney. She puts down her 10 grand as a retainer. He works a plea deal for her, but the death penalty is still included in the plea deal.
That's what you got. That's all you got.
And so that was his first client. He got her. It took 27 years, but he got her out of prison. But that spurred his interest. He picked up his family, moved from Illinois out to California, started the California Innocence Project. So I'm sure that first chapter has a lot to do with that client. And so we may dip into that for the first dose.
That's unbelievable. Now,
really
along with those names things, Susie Q. Boston said, someone in Melanie's chat. I love that. I'm going to love this. Call out your husband, Dr. Michael Kenney Baden. Okay?
Well, you guys, you've really become one person.
I love it. We all the three of us have become, I think, one person. No, it's two of us because I would have loved it even better if it didn't have an A in it, so that we could have merged the three of us. That's right. That's even great. Well, yeah.
Yeah, what would you have then? Linda Michael Bryant? No, Linda, I don't know what you have.
No, Linda Michel as my Siri Koji Michel. And there you go, become a Justice Served TV book club member. First episode out now, TV join. Okay, that's Missy plugging that. And Dorothy Kiley, become a new member. You can now go to the book club and listen to that episode and listen to the episodes of The Hunt to get ready for episode 2. Thank you very much for becoming a member. Enjoy Shmehar. Hi, Joy. Justice Served TV. Did you see Donna's prison daughter is out and gave an interview? I think on Surviving the Survivor, right? I don't want to mention the channel. I mentioned it. Was. But if you want me to, I will. It was great. And I think she said that Donna was offered a plea deal. She was saying,
Well, that was always talked about, and we assumed it was because that's just typical. Right. But what were the terms and what was the motivation? Clearly we don't know because she didn't take it. What was her name? Dreeny? Is that right? Or Dreena? Dreeny or Dreena? Dreena. I wish her the best. She's 27 times convicted, mostly drug-related offenses.
She is the one. Yeah, she's the one that Sherry Schreiber ended up doing our addiction special. After we watched that, we talked in our chat about her because she had all her offenses were through to drug use and addiction and recidivism. And we said, look, we need to do, since it was National Recovery Month, discussion about that. If you haven't listened to that episode, Sherry Schreiber was just great talking about that and also just absolutely great.
And as I recall, that was spurred by somebody bad-mouthing you. So that's how.
Yeah, somebody bad-mouthed me because I mentioned something about her drug addiction, but she mentioned it. That was the whole person that was on the stand, and that's what she was talking about was her drug addiction.
Okay, so Madonna, jail friend interview on Loophole Lawyer. Our buddy at Loophole Lawyer.
Yeah.
Are you sure he did the interview?
Okay. Well, Madonna, I always called them Adelson, Donna Adelson, Madonna, for her mom work.
It was Dreena.
Okay. Yeah. Madeira Beach caregiver member for 11 months, and Madeira Beach has been a big supporter of this channel. Yeah. And Olivia Nile, thank you. We love you too. Love Justice Served TV family. We're also lucky for the incredible, thoughtful interviews she provided to us with Michael Easter among them. Yes, Michael Easter, I'm gonna have to talk to Alan Jackson because in like 2 days. Michael Easter is almost up to our interview with Alan Jackson. He's
That's
such
funny.
a beast, that Michael Easter, and I say it in a good way because we all learn. It's a very complicated area, and yet
Mhm.
he makes it so simple. I can't imagine him on the stand. I would imagine that he on the stand, I mean, not that the prosecution case wasn't destroyed in Karen Reed, but he would have, if there's a
Oh
double
my God.
destruction,
It would
he
have
would have
been,
destroyed it
yeah, it would have been,
even
white
more.
flag would have been raised. And of course, he's a good looking guy.
Yeah,
Typical man.
Oh,
yeah,
sorry. Wrong one.
our chat seems to talk about that. But yes, thank you very much. And that came about because of our own Michael Bryant. I want to give him credit again, Olivia, because when the motion was denied to put Michael Easter on for both the geofencing and all the police areas, he was a police expert, right? Michael Bryant actually reached out to him and he said, well, I can't come on now, obviously, because I'm in trial. And then after the trial, Michael Bryant then reached out to him again. Well, can you come on now? The trial has ended. And he agreed. I guess nobody wanted a tech person on. They thought a tech person was going to be boring, was not going to be interesting. So he came on. And of course, his first episode, he was a humongous hit. They couldn't
Yeah.
wait for Data Daddy or Data Daddy, depending on how you say it, to come on again, as he's been named a number of those little names. He even got his own babies. He even got his
Yeah,
own
remember that?
Karen Reed
Yeah,
babies.
we
Yeah.
did have a little thing.
Because of his appearance on our show. And then
I
he
was so
been
glad that
on
he
a number of times.
returned my inquiry, but then you start wondering because I had never seen him and he didn't have stuff, out there. So it's kind of the guy sounds amazing, but I don't know. And of course, he turned out to be more than amazing, and we're so
Amazing.
glad that he's made repeated visits, and we
Right.
ain't done with you yet, Michael. So
That's right. I know. And let me just give you one more. K. Schmidt gifted
Thank
5
you, K.
Justice
Schmidt.
Review memberships. And let me tell you, they've already been given out. We have nothing to do with them being given out. They're given out immediately after they're gifted. They go to people who usually end up paying them forward because it's $2.99 a month. And for a lot of people, that's a big expense. And we appreciate the donations, the gifts, and everyone, I think, as a member, appreciates being a member.
Hey, on that point, before we get to what we're actually getting into tonight, Missy, don't we get like 10 memberships a month that we're supposed to be able to give out? And I don't recall that happening over the last, I don't know, couple of months. So
Right. I don't remember that either.
I don't. So if you could check on that, that'd be great. Okay, so Zwerner versus Parker. This is the case in which the first grade teacher was shot by a 6-year-old student. She has sued in civil court the former assistant principal for basically not doing enough to protect the teacher from being shot. Okay, it's a horrible case, and she survived. She has massive injuries to her hand, which she apparently was using in an attempt to, like a reflex. Somebody points a gun at you, you might, goes up through her chest, misses her aorta by 2 centimeters, which is less than an inch, by the way, 2.54 centimeters in an inch. So less than an inch, it misses her aorta, and she's dead if that happens. So she's there suing. 40 million is this weird number that's been thrown out there, and the the defense did a good job today of throwing that out there as kind of an outrageous number. Who knows what the number might be, but 40, it does sound like a lot. She's got 53 years left if you look at the actuarial tables before she dies. So that 53 years is a factor. How much per year should she get based on what happened to her? But here's the thing that we started talking about the other day: contributory negligence versus comparative fault. I didn't realize.
Why don't we explain that again for people that
I
weren't
will
in
do
the
that.
chat?
I will do that. Anytime you have a negligence action, which is what this is basically the plaintiff, the teacher, saying this assistant principal breached her duty to me based on her role as an administrator to protect me. And that breach caused my ultimate injury. Therefore, there are damages. Give me the money. Okay. Comparative negligence means that even as the plaintiff, maybe she did something wrong too. Maybe she was 10% wrong because the kids in her class, she didn't remove him from the class. She didn't remove the class from being around him. She didn't isolate him. She didn't take him to the administrator's office. How much fault, if any, is on the teacher? Okay. And in a comparative fault state, and you know how many states are not comparative fault anymore? We know Virginia, 4.
I remember I think it was when I started practicing about 30 years ago, 20 years ago, states started moving over from contributory negligence to comparative fault because it was so
here's why.
unfair.
Yeah, because here's what contributory negligence means: if the plaintiff is found even 1% at fault, 0, nothing. Virginia is a contributory negligence state. So is Washington, D.C., so is
Wow.
Alabama, and what was the other? There was another state.
Wow.
North Carolina.
That's it? Those are the four?
Yeah,
and they're not even a
that's it.
state. 3 states and 1 district.
I think I'm missing a state, but I think there are 4 states and then D.C. Everybody else has moved away from that for the reason you mentioned, because this case, this teacher, who I don't think anybody would blame 100%, she could get 0. So to get to that analysis, I was keyed in on the instructions, right? Because you want to know what the court is telling this jury, and then you want to look at the verdict form. And I think they screwed the pooch on the verdict form. What a surprise. We've never seen that before. I think they got the instructions right, though. So let's listen to just the first couple of instructions.
Okay, we have to get rid of this
What happened?
essaying the pooch. I'll tell you why.
Okay.
I'm taking it personally for 2B.
I'm just way too sensitive. Whereas Domino gave me a thumbs up, so I don't know. Anyway, and our dogs are both male. So
Were you going to say way too sensitive for you?
Yes,
How we
you're not.
dishonor
You can't be
our
expressing
friend.
outrage on behalf of your dog. I'm sorry.
Yes, I can.
Okay, so this is really the very beginning. Whoops, the very beginning of the instructions, and you'll see what I'm talking about.
For your decision.
Hold on. Okay.
Jury instruction number 1. Your verdict must be based on the facts as you find them and on the law contained in all of these instructions. The issues in this case are: 1, was defendant Ebony Parker grossly negligent? 2, was defendant Ebony Parker's gross negligence a proximate cause of Abigail Zwerner's damages? On these issues, the plaintiff has the burden of proof. Number 3, was plaintiff Abigail Zwerner contributorily negligent? 4, was plaintiff Abigail Zwerner's contributory negligence a proximate cause of her damages? On these issues, the defendant has the burden of proof. 5, if plaintiff Abigail Zwerner is entitled to recover, what is the amount of her damages?
There you go. That in a nutshell, to me, is the case. And you heard it laid out very clearly. Was the plaintiff a contributory cause? And if so, then you move on to damages. Okay, so that makes it all very clear.
But the defense has to prove that beyond the
Yes,
preponderance of the evidence, right?
yes. And
By
again,
preponderance of the evidence.
proximate cause, this is where everybody says, you mean approximate cause? No. Proximate cause, you really could just take the word proximate out. It just means connected to the ultimate cause. It's next to it. So the cause of the injuries, that's what you're looking for. Okay, so this is fine. That instruction is perfectly in line with logic and the law if you're in a contributory negligence state. If you find the plaintiff was contributory negligent, you have to find that her negligence was a proximate cause, not the proximate cause, a proximate cause of the injuries. Okay, so I get that. I'm okay with that. Let me zoom ahead here now to, he holds up the verdict form. I almost tried to get a freeze of it so I could see it.
Right, because they didn't publish it, right?
They did not publish it. Let me see if I can get back here where I was. Stand by. This guy, I will tell you, when we see some of the plaintiff attorney's work, he was not shy on the visuals, which I'm a big fan of. Demonstrative evidence used. Big fan. I'm not sure he didn't go too far. But anyway. Okay, hold on here. He really was pretty efficient with the instructions. Oh, there it is. There it is. See that? That's the verdict form. Okay, let's see what he has to say about that.
On the top line or the bottom line, if you put a X on the top line of your signature for your jury person.
Here we go.
So when you go back after you have made your decision unanimously, you're going to check a box. Put an X on the top line or the bottom line. If you put a X on the top line, you will fill in the amount of the award, and then any interest, the date that interest runs from, or an X on the line next to line 2, and your jury person needs to sign by both name and number.
Okay, here's the problem, or many problems I have with this verdict form. First of all, the whole asking the jury to put a start date for the interest, to me, boggles my mind. That should be a matter of law. That's handled after.
Yeah, usually that's a matter of court rule.
Yes, that's going to be determined by somebody other than the jury members. But okay, fine. First of all, did you notice he said unanimous?
I heard that. I heard
So
that.
in Virginia, they start with 9, and then they just pick 2 numbers at the end, which I appreciate because I don't want my alternates not invested in the case.
Right. I agree. I like that's the New
I
Jersey
want,
way it does.
yeah,
Right. That's what you do in Jersey. You
California
pick it
the same
after.
way. But we've seen many states where they go in knowing they're alternates, and to me, you're checked out. Now you're pissed off because you were totally into it and you were an alternate. So number 5 and number 32, thanks. Have a nice day. Except that they're still on the hook till Friday, and
Right,
so
because
they
the
have to be
same as
called in at some point.
same as New Jersey and California, unlike apparently Massachusetts, where they're like, bye-bye, you could go home now.
Yeah, I mean, that is
It's
so
been
optimistic.
real.
It's like that day somebody could have a heart attack, and then the parties will have to decide: do we go forward with 11, or do we have a mistrial? It's just so stupid to not wait. Why not wait? Anyway, so they start with 9. Now they have 7, and it has to be unanimous. So it's weird. Virginia is weird across the board, from the contributory negligence issue to the number in the jury. It's just weird. So.
Yeah. And by the way, I did get a little bit of a screenshot, but that is a remove. That wasn't the one I got. I wonder what happened there.
Oh, you're trying to get a shot.
Oh, I can't. I can't add it while you're playing. Okay. All right. So,
okay.
That's right. Okay. So you keep
So
playing.
here's my problem with the verdict form, other than the weirdness about the interest. Right. It's just yes or no, basically. It's did the defendant cause the injury, and was the plaintiff contributorily negligent? It doesn't say what the impact of that is. It doesn't say, well, if she was, then she gets nothing. It basically allows them to find that she was, and then get money, and then that's the end of it. And I think without some sort of better, there's like a question missing, in my opinion.
This reminds me of when the early days when the death penalty was reintroduced, and everybody, after a case called, Furman versus Georgia, not Mark Furman, okay, the U.S. Supreme Court, and after death penalty was reintroduced as a result of that case that had unintroduced it, there was a question of how you proceed. So juries weren't told that if they found, for instance, the mitigating factors outweighed the other factors, right? You have the factors that will give you the death penalty, and then you have mitigating factors. And I'm only using that term because that's the term that's important. They weren't told that, so that jurors didn't know. They may not wanted to give somebody the death penalty, and instead they would find the aggravating factors would outweigh the mitigating, and they didn't realize that there had to be more to do, and there was lots of litigation over that. Now we've kind of settled into an agreement through states as to whether each individual one outweighs, or if one mitigating factor outweighs the aggravating, it's all over for the death penalty. But there were years of litigation over that. That juries didn't know the result of what they were finding, what would occur.
Yep. And they we'll talk about the insurance issue too, because they shouldn't be worrying about whether there is or isn't insurance, and it's a very unique situation in this case. Okay, I know I'm belaboring this, but it's so important.
And you're thinking about it right now. We don't hear anything.
Oh, once again, I've done my
Michael gets so into listening.
I'm just having my own party here. Sorry. Just me and the judge. Okay.
Plaintiff Abigail Zwerner. After you have made your decision unanimously, you're going to check a box. Put an X on the top line or the bottom line. If you put a X on the top line, you will fill in the amount of the award, and then any interest, the date that interest runs from, or an X on the line next to line 2, and your jury person needs.
And the line 2 says, no, she wasn't, the defendant wasn't at fault. But where's the line that says, do you find the plaintiff contributorily negligent? Yes or no? That's it. Because you can't be less than 1% contributorily negligent. And by law in Virginia, if you're even 1%, you get nothing. So they could find that she was contributorily negligent, but it's nowhere on the verdict form. So I think if I'm the defendant and I get that result, I'm appealing that in a heartbeat. And again, you're suggesting if they didn't raise that, they may have a problem bringing it up on appeal.
Well, they have to raise it. They have to object to it, yeah, unless it's a constitutional issue. You have to object.
That's
to
what I'm
anything, including
wondering.
a jury
If it's
form.
if it's statutory, and if there's some other Virginia law that might protect the defense on that front. This guy's been, they also moved for a mistrial today, and we're gonna see why, because I'm gonna zoom through some of the parts of the closings. When I heard this, I was shocked. Hey, look, I'm bringing it back on before it started.
and we may be able to hear it. You're so funny when you do that because you're so into like.
I know, I'm like watching it.
Like, whoa, watching it, and
what the hell are you doing? So here, this is the attorney. Let me make sure I pronounce his name, or at least do my best. Young guy. This guy's 33 years old. His name is Kevin Benazian, Benazian. And we're just going to jump into the middle of this, and you'll see some of his visuals. You'll see his style, his passion. I think he does some things amazingly well, especially for a youngster. But I think he goes over the top in some ways.
By direct and circumstantial evidence. What does that mean? I don't need to see the rain coming down from the sky to know it's raining if I walk out in the morning and there are puddles on the floor, right? I don't need to see the rain. I know it rained.
Classic law school.
And when Dr. Parker says, in response to, did you search the person? We checked the bag. What that tells us is that was a real threat. That it was accepted as true, so much so that we needed to check the bag. All this talk about we didn't think it was a real threat. It wasn't a credible threat. Why are you agreeing with Ms. Kovac to search the bag if you don't think it's real? And when they say, did you search the person? And the response is, we already checked the bag. Guess what that tells us? We thought it was real, and we don't know where it is anymore. We don't know where it is anymore. And then the boy outside of Miss West's classroom crying, remember? Crying, not wanting to go back into Mrs. Z's classroom where he's supposed to be. Says bullets and shoot. The boy showed me bullets. JT showed me bullets. And he said, if I told anybody, I would shoot. Bullets, shoot, gun. The only way you can shoot a bullet is if you have a gun. And to tell us that telling a boy that he will be shot is not a threat. Not a threat. Goes against the very language that 6-year-old used. And then he goes and has a conversation with her again. You heard from Miss West, who said he was crying scared. I talked about R a moment ago. He was crying scared. And I suspect what you're going to hear from the other side is, well, we didn't get good information. Remember that from Dr. Klinger? Well, we didn't get good information. We didn't know that he was crying and scared. Somebody should have told Dr. Parker that he was crying and scared. When we go out onto the road,
here we go,
and there's a stop sign on the corner of the street, tuck it behind a little corner or right there for us to see either way. It's our job as we're driving down the road to see the stop sign. It's our job to look out for the stop sign. It's our job to find the rules of the road and the signs of the road so that we can then govern our behavior. It was Dr. Parker's job to investigate. The manual that governed their relationships amongst each other told her that you must first assume it is credible unless analysis suggests differently. cause the student making the threat, if known and on campus, to be immediately removed, pending further investigation. What does that mean? That means you can't stick your head in the sand. You cannot stick your head in the sand and then come into court and say, I didn't have the information when it was your job to find it, when it was your job to look for it and to do the investigation and to talk to that little boy who saw the gun and to talk to those two little girls who talked about the gun and to talk to all of these people. If it's your job to investigate, which their handbook tells them it was, you can't come into court and say, I'm going to close my ears, close my eyes, put my head on my desk, and then use that as a defense to my case. The law says you know it because it was there to be known, because the stop sign was on the corner of the street and it should have been seen. It's no excuse to walk into court on a traffic ticket and say, well, Judge, I didn't see the stop sign. The stop sign was there. The stop sign was there. Feet, yards from her. And then, in my view, you turn up the dial. Because at this point in the afternoon, there is a accumulation of information. We saw a gun. It was supposed to be in a backpack. We don't know where it is. It might be in his pocket. It was shown to a boy at recess with bullets. We still don't know where it is. He's crying, won't go to class. And another request. Can we search the person? And I suspect they'll come up here and they'll say, well, Mr. Rawls told you that he didn't think it was credible. My response to that is let's look at actions, because our actions speak louder than our words. Did we hear any other evidence of Mr. Rawls coming and asking to search just kids at random when he didn't think there was a threat? We talked, and all of the evidence is that searching, and even Dr. Klinger told us, searching a child is something that you do delicately. You only do if it's necessary. That's what they're taught. And he came to her directly and said, have we searched the boy? Again. And he wasn't the only one in that moment. Because in that moment, when she heard, West heard, that they had not searched the person, Mr. Sims goes and stands outside the door of Mr. Rawls and Dr. Parker and says, are we searching the person? That's 3 times somebody is asking her to do this. 3 times. Countless times where we're talking about the boy throughout the day and a gun and where it is, but 3 times to search the boy. That should be flashing at you to act.
Okay, so let me get your thoughts on this before we move on to a little bit more of his.
I really like his style. It's not
He
my
didn't. I didn't see him look at a
style,
note once.
but it's not that. It's all of a sudden I was engrossed. I wanted to hear what he was saying next, and I started thinking as a lawyer, of course, and thinking to myself, well, what is a stop sign? That there was
Yeah.
the weeds weren't cut down because the county never cut the trees growing. And we have to search it out. But I really liked him. I really
Some of
thought
his
it was
visuals
terrific.
were a bit much for me. The head in the sand, and some of those very literal. Okay. I think he was able to use his PowerPoint really as his notes, because
Right.
he had it so down that each of those slides triggered whatever he was talking about next. Very personable, very connected to the jury. You could just tell. He got, like I said, I felt he went over the top a couple of times into the cheesy category, but overall, especially for somebody relatively young, I was impressed. And it's funny, when I watch some of the pretrial activity, maybe it's my biases, but I can tell a plaintiff attorney from a defense attorney. Just this guy is just a little slicker. The defense guy was
Oh,
no,
come
he,
on.
the defense guy was good mechanically. He was there, just not quite as slick.
Well, wait a second. What you're meaning saying slick, what you mean is that he is connecting with the jury. He
And
is
I mean polished.
he's polished. But yeah, polish is, but slick sounds like, you're the ambulance chaser.
No,
Polish is
I
good.
wouldn't. I
He's
wouldn't look at it
polished, okay?
derogatory. I think he's
You know,
he's slick. The guy, he's smooth and
he's
slick. They're very
well,
similar.
no, they're different. They have a different connotation. Words matter, and
You
they
and your
have a different.
sensitivities are driving me
No, they have a
crazy.
different connotation with it. By the way, with my sensitivities, I will point out that Ohio Palm Mom it thinks that phrase about the dog is a nasty phrase. So I'm just pulling out, jurors. I'm
Just
assembling
grabbing those on your
I'm
side.
grabbing my jury panel right here. Your jury panel is the most important people in that room for your verdict, right? So I'm grabbing my jury, Michael Bryant.
Okay. What I want to do is jump now to the defense attorney. And we'll see some of hers, and we'll see her demeanor and her style. Very, very different, I think. Not any more or less efficient, but very different. She uses some great visuals as well. And I thought of something as I was watching his closing argument, and now I've forgotten what it was, but it was very important.
But I just tell you, the discussion the chat's having is the discussion that members of the jury room are going to have, not knowing the effect of what contributory negligence can do in a case, and I think that's really wrong.
And again, the verdict form doesn't help them in any way. And there's nothing. It's not that the court should tell them, by the way, if she's even 1% contributory negligent, she gets nothing. They should not know that. Yeah. But when they're coming to a decision, they have to let the court know that, because the court then would know how to act, and it would nullify. I mean, she could get 20 million. I don't know what you're going to get.
Yeah, so I have the view, as you know, that that except for the fact the way this thing is written about contributory negligence, what the jury doesn't know, 1% you get nothing. I mean, I would want to give her money. So if I'm in that jury room, I'm finding that the plaintiff proved their case, not knowing that, maybe if you start negotiating with the other jurors who don't feel that way, well, okay, well, we can say that she's a contributory negligent too, but we don't know what the effect of that is. And I do think it's wrong. But I want to interject here a different point. I want to talk about.
You're interrupting yourself to inject.
No, I'm really interrupting you. Going on for 1 second, because our chat is really divided on this, as they were last night. All right, and one of the things we've talked about this week, and that got you into like people commenting, was a discussion of appearance in the courtroom, or appearance, right? If you and I were like slobs coming forward, would people like be watching us, right? Probably. I
don't know.
Stop. Stop. I'm giving you a plug here. Probably not. But one of the things, are you liking this lawyer in chat because he's cute, because he looks good, because he kind of, and I don't want to put politics into it, and I'm not talking politically, I'm talking about manners and how you look. He kind of reminds me a little bit of the former Prime Minister of Canada, Justin Trudeau, with a little hair going up, but the younger look. And we talked about Mike Easter. We see our chat when Mike Easter is on. And then we talked about Heather, who did the interview of Whiffen and her looks. And the point I'm trying to make is that as trial lawyers and as TV commentators, we actually get schooled in how you're supposed to dress. Like, I'm never supposed to, all guys like my big earrings, I'm never supposed to have those on. I'm supposed to have like a little tank top and a blazer and a small little necklace, because the theory is that if my clothes detract from me, you're not listening to me, you're looking at my clothes, which a lot of you are. And I it's my own show. I think that you listen to me because you may like the clothes. I have a different view. But I just want all of you to think about that. Do you think that you like him, and when you see the defense attorney, or dislike her because of how she looks? Put that into your hopper.
Yeah, it's a factor. I remember talking to a couple of jurors after a trial. It was a month-long trial, civil trial. And so we're asking, of course, you want to know, what did I do wrong? What did I do well? And they focused on, we were the defense, the plaintiff's attorney had a white belt on. White belt. And that, for some reason, told them something about the guy. It was bizarre.
Right. Okay.
Anyway,
And
I
when we talk about this further in a show or maybe a 10-minute episode, I'll tell you about when I tried a case and the juror foreman asked the sheriff, the bailiff, whatever, to tell me about my headline being uneven. Okay, and she was a seamstress and couldn't remember. So things
it's
matter.
amazing. Yeah, it is amazing. I remember what I was thinking about, and this will relate to the motion for mistrial. You'll recall the defendant did not take the stand. Obviously,
Right.
doesn't have to. This is not a matter of criminal concern with the Fifth Amendment, although you'll see how that comes up. Here's my biggest concern with her not taking the stand. There was a body cam video of the day this happened, and you see the defendant at her desk in her office. She's wearing a hoodie, very casual looking, but also very lackadaisical just about what's happening. It just seems low key, like, I don't care. Her sitting there in that courtroom deciding not to testify, to me, reinforces what that jury saw in that body cam. There she is, just sitting there like she did that day, didn't care to get up and investigate, didn't care to go to the classroom, see this kid, didn't care to follow up with all these concerns people had. She just sat there. And here she is in trial, just sitting there. I think that's a bad look.
Interesting. Although they were teaching like first graders, you know.
Well, I'm not talking about the teaching part. I'm talking about
yeah.
her administration. You know, she sat on her ass that day. She's sitting on her ass here in trial. I can see them conflating those.
That's
Okay, so
my partner.
this is the plaintiff, the defense attorney, Danielle Hogan. No, sorry, it's not. It's Sandra. My notes are brutal. Sandra, Sandra something. So let's see how she differs in style. And I'm actually going to put it up here. Hold on a sec. And you'll see some of the lists she uses. I think are very effective.
Think about this. Who was the second person that day to hear about whether JT might have a weapon? It was Miss Zwerner. She was in the classroom when this went on with Miss Kovac, 30, 40 minutes, whatever it was. She sat here and she agreed that discipline is the initial responsibility of the teacher. She had dealt with misbehavior. How she dealt with student concerns was to first talk with the student. She told you she had taken a student by the hand, had removed a student from the classroom. And that was JT just 2 days before. He had thrown her phone, broken her screen protector, and she took him by the hand and she took him out of the classroom and brought him over to Miss West's class across the hall. She also told you that she had a classroom phone to call the officer parents, and she had requested assistance from guidance before, had requested help on the walkie-talkie. Miss West across the hall had the walkie-talkie. And the same day that JT threw her phone, she went over with JT and had Miss West get on the walkie-talkie and call Mr. Rawls to come and get them. So she knew how to remove him from the classroom. She also knew how to evacuate the classroom if she sensed danger.
Too much writing on that one slide, Michael.
Showed her the text.
Well, she kept using the same slide
Yeah,
over and
before.
over. It wasn't like she was clicking through large displays. And there's another one. I want to get to this because I think it's this is about the history and what she knew and what she didn't know.
Now, see,
in
I
terms
had
of
it
procedure.
just as turns a jury's reaction. Okay, I didn't watch this. That's the first time I'm seeing this. And when she said, "It's Miss Werner," almost like she was,
Said what?
who was the first person that could have taken it? It's Miss Werner. The way she said that, she changed her voice pattern, and instead of saying "It's Miss Werner," right? It's the person seeking the money. She went, "Oh, condescending," and that just threw me off right there. And quite frankly, I don't want to listen to anything else she says. I mean,
Wow.
but these kind of visceral reactions are the reactions that jurors have. Now, whether it matters in this case, I don't know. I'm just telling you that was my visceral reaction to how she used her voice.
I don't think that's inappropriate. And I think in general, she's a cold fish. I mean, comparatively, she really doesn't come across as very warm. I understand you can be a little defensive as the defense counsel, saying, but you dragged my client in here for no reason. Okay, I think you could have a little tinge of that, but I don't think you can go over the top to where you're downright unlikable. And I think she's a little like that. I'm looking for one specific graphic she used, which I think was very, very helpful. And it had to do with what the plaintiff did not do. Because remember, the goal here is to find somebody other than your defense client, right? To blame for this, because somebody wants recompense for this. There's somebody got shot.
She got shot, right? And I think breaking a cell phone and bringing the kid JT across the hall to sit. First of all, that gives motive, and to me, that underscores the reliability of the report of the gun and the fact that he talked about bullets and wanted to shoot. Okay, because he was after the teacher. That gives him a motive, and that gives the others, the rest of the administrators, to take the report of the gun seriously. And to me, that doesn't help her as far as I'm concerned. Now, I know all of you are going to maybe disagree with me, and that's fine. But if I'm in the jury room, that's what I'm arguing.
I would disagree to this extent. She couldn't throw up her hands when this happened and say, whoa, I don't know how to do this, or what happens when there's a problem with one of my kids. Well, yeah, you do, because here's the same kid had a problem.
But I don't think she did. She thought somebody was reporting it, and then the administration's duty is to search him and search his locker, which they did not do. And Lindsay, we talked about that yesterday.
She wasn't oblivious to it. It wasn't like, I know nothing, everybody else knows, I don't know. She knew too. She knew of the concerns. She just didn't leapfrog the people in the middle to go directly to Parker until later in the day. So I think it is helpful for the jury to know that this woman knew the procedure. In fact, with this exact kid, had an issue before, went across the hall to Ms. West's room, got help there, had the walkie-talkie to call Mr. Rawls, who's some intermediary in the discipline chain. So I think it helps. I don't know if it wins the day, but it's one avenue that the plaintiff can't use to excuse her behavior. Okay, so let me see if I can get
hands in his pockets and are telling JT to keep his hands in his pockets. She had discussion with Jennifer West about that, the lead teacher with the walkie-talkie, and discussion with Amy Kovac at recess. But there are things she did not do.
This is the important
She did not follow up with the two little girls. She did not speak to JT, did not remove the backpack from the room, did not remove JT from the room, did not take JT down to administration, did not evacuate the classroom, did not call the guidance counselor, did not make use of the walkie-talkie, and did not call the parents of JT. Did not seek classroom coverage to personally discuss any of this with Dr. Ebony Parker. No visit, no call, no email. You'll get a jury instruction on contributory negligence. It is the failure to act as a reasonable person would have acted for her own safety under the circumstances of this case.
And to me, that's the argument. That's what this jury has to understand. But the verdict form, again, is not going to help them. I know we're getting late already here. Holy cow. I want to get to the rebuttal, because that rebuttal argument is where some issues popped up, which led to a motion for a mistrial.
And while you're finding that, I would point out in our chat, we have a number of nurses, pediatric nurses, intensive care nurses, hospice nurses, all talking about that walk of honor when somebody's donating their organs. So welcome, and keep that discussion going.
Yep, nothing more worthwhile.
Because one person had all the puzzle pieces, and that person is Dr. Parker. And then you talk about going onto the playground. And what about what you did in the classroom? And why didn't you take them off the playground? And why didn't you search the backpack? The only reason they're able to point that finger of doubt at every single person in this school, except for Dr. Parker, is that Dr. Parker sat on her hands. At 12:21 p.m., if Dr. Parker was doing her job, she would have walked into that room, grabbed that book bag, and none of these questions would have ever been asked ever again. And because she sat on her hands.
And that's what I'm talking about. She sat on her ass that day. She's sitting on her ass here. Now he's going to get to the testimony. I think it's coming up here.
They now get to point the finger at every other person at this school and said, why didn't you pick up the ball that I dropped? Why didn't you pick up the ball that I dropped? And then they talk about what Mrs. Zwerner could have done sitting in that classroom. I want you to look at instruction 23 when you get in the back, okay? Instruction 23 says, a plaintiff has the right to assume that a defendant will exercise ordinary care until she realizes, or in the exercise of ordinary care, should realize that the defendant is not going to do so. What does that mean? That means that when Miss Zwerner talked to Miss Kovac and they went and told the principal, who they knew it was her job to deal with a gun on campus, she had the right to assume that somebody was actually going to come into her classroom and do something about it. For every minute, she had the right to assume, whether it was in the classroom, on the playground, in the hallway, whatever, they had the right to assume that somebody was going to do their job and take care of her. And then they get up and say, oh, the expert's lying because she mixed up a guidance counselor with a teacher. But it's not just the expert that's lying. They're all lying. They're all lying. Miss Kovac didn't tell you the truth. Miss West didn't tell you the truth. Mr. Rawls, I think, sounds like they told you the truth a little bit. Miss Zwerner didn't tell you the truth. Everyone's lying. Everyone's lying. What does that tell you about common sense? They had days of evidence where you got to go home on Friday. Not a single person called. It was their turn. The only people they called as an expert were the people that they paid to come into this courtroom. And you're telling us that we're the problem for paying people? If anybody supported your position, march them onto that witness stand and tell us all the materials that Dr. Klinger reviewed, all the materials she reviewed, body camera, cops, witnesses. They help you? Put them on the witness stand. You didn't sing a single one of them. You didn't see a single one of them. And if you didn't believe every word that was coming out of their mouth, and it's not exactly how it happened in your office, then get on the witness stand and tell us. There was all this conversation in jury voir dire about what it means to plead the Fifth Amendment. Ladies and gentlemen, somebody doesn't plead the Fifth Amendment unless they sit on that witness stand and say, I plead the Fifth. In a civil case, you don't have the right to remain silent until you actually exercise your right to remain silent. And not a single chance, they didn't want to take a single chance of her answering a single question. And if they didn't believe them,
Uh-oh. Oh, problem.
Sidebar overruled.
Then I would ask to voice my objection on the record, Your Honor.
You can after closing. Go ahead, Mr. Bailey.
and then we talk about Taylor Swift. Taylor Swift. What I want you to do is, if you watch that, if you look at that clip, I want you to read the second sentence. And the second sentence says, I am the first grade teacher that was shot by a 6-year-old. What does that mean to somebody? That your identity, I don't walk around saying I'm my mother's child. I'm a first grade teacher. And Miss Zwerner walks around life feeling like she has to tell everybody, this is me because this defines me.
Okay, that was the critical part I wanted to get to there.
That's
I mean,
a little bit of an uphill, but the judge didn't pay much attention. He said,
It was,
yeah,
it was
yeah,
like he
afterwards.
was, it's not his job.
No, it's
and-
like he didn't. He's this is not going to be important. I'm not looting
No.
this trial because of it.
Yeah, and so that's where I'm going to go to so we can wrap this up. But yeah, I like he uses these cards. What he does is, he said during the course of the trial, certainly he does it during the course of closings, he just makes a card with a note about something he wants to address, and then he uses those. And he made a point of showing a big stack of cards and that he was not going to touch on all of them, but he hit a few. And then when he started getting to that witness testimony, I went, oh, this may go sideways. And it did. So what the judge allowed was for him to finish. Then he sent the jury off to begin deliberations. And let's see if we're to the point where they argue about it.
Has the plaintiff gathered all the exhibits that are going back? All right, so how we are going to proceed once the deputy comes back, there is you.
Oh, that's right. He had a couple extra instructions to give them before they toddled off. Okay.
While you're looking for
That's a
that,
burden shifting.
Yeah, this is the
jury
I'm sorry, go ahead.
while you're looking for that, I just want you to all think about, though, how did the defendant look as she's sitting there? I thought she looked kind of smug. I thought she looked kind of
I thought she looked uncomfortable and
uncomfortable.
attitude. Little
Yeah.
attitude.
Little attitude, but uncomfortable as he's making his points. Remember, the jury is always looking at the parties. They are staring at the parties to see if they can get a glimmer of who they really are.
Yeah, and you see the plaintiff, anytime the jury came and went, she had her little She has kind of a naivete about her. She had a cute little smile, as they
Oh,
were
she's a
coming
first
in.
grade teacher.
I think it's legit. I don't think it's
I
acting.
think it's absolutely legit. She did Zoom, mixed her first year of teaching, mixed teaching with Zoom. I mean, she's a young kid basically.
Yeah.
We're dealing
Oh,
with
yeah.
first grade kids, and I don't think she deserved to be shot. I'm
I don't
buying.
either. And I'm
I'm
telling you
buying
right
the
now,
plaintiff's argument.
if this case is nowhere other than a contributory negligence state, I got no problem the way it plays out. Whatever they determine is her fault, if it's 1%, 5%, 20%, whatever. Because I do think she does share some of the responsibility, and I'm fine with that. That's the way the system works with comparative fault. But in one of these four states,
I think the administrators would share all the responsibility. I think when she goes and tells people, and they're supposed to go from there, it's not her job to pick up the administration job. She's not getting paid for that. So we disagree.
I
In
totally
the jury room, we
disagree.
disagree.
I'm in the room. I'm in the freaking classroom. So the hell with anybody else saving my ass. I'm going to take care of myself and my kids in my classroom. That's it. Now, it's great if they can step in and send, as the plaintiff's attorney argued at one point, the cavalry. She was expecting the cavalry to come through the door. Great. But take some responsibility. I just don't like people shirking responsibility when they're there.
So if we were in Florida in that horrible case, all those teachers who got killed, if they had that kid in class, have a responsibility to report everything that he did. I don't buy it.
Which one are you talking about? I can't keep up. You're
Parkland,
talking about
Parkland
shooting?
Parkland, yeah.
Mhm.
Yeah, I'm just using that because everyone's aware of that.
That's totally different. This is a kid who just comes in blazing. There's no lead up.
Yeah, he told somebody else he had guns and bullet. He would just shoot a bullet. I mean, that you shoot a bullet equals a gun. I agree with him here. So anyhow, what Michael and I are doing is we're having the same discussion that the jury room is going to be having.
And before they got to it, or as they were beginning, here's the mistrial motion based on the reference to the Fifth Amendment.
Which I'm sure the court has anticipated. Judge, I move for a mistrial in this case. The standard is a manifest probability of prejudice. Two problems. In rebuttal, closing argument, plaintiff's counsel stood up here, pointed to my client directly, and asked the jury point blank to draw an adverse inference from the fact that she did not put on any additional evidence. This constitutes classic burden shifting. The jury instructions tell the jurors, this is black letter law, that plaintiff's counsel, the plaintiff bears the burden by establishing by a preponderance standard each element that forms the basis of her claim. This is impermissible burden shifting. That error is compounded by the fact that Mr. Beniossen needlessly stood up here, again, pointed directly at my client and said that she didn't really invoke her Fifth Amendment privilege. She didn't invoke it whatsoever. She didn't put on any evidence. So it's fair game. You can draw an adverse inference against her because she elected not to testify. The problem with that, Judge, is in Virginia, I understand there's a distinction between the way the Fifth Amendment operates typically in the criminal context versus civil. And typically in the civil context, what has been addressed in the case law has been generally there's no blanket right to invoke your Fifth Amendment privilege. They've not addressed this in the context of testimony at trial. They've only addressed this in the context of pretrial discovery. And they've had instances where people have invoked the Fifth Amendment privilege as a way to not answer discovery questions. And they've held generally there's no blanket privilege. There's case law in other jurisdictions in the federal courts, Judge, that have held that under some limited circumstances, an individual can assert a blanket privilege, can assert the Fifth Amendment, and refuse to take the stand. And all the protections that come with that, the full panoply of protections, would come and would redound to my client's benefit. That would include 8.01-223.1, which is memorialized and enshrined this constitutional principle that when someone faces jeopardy, legal jeopardy because of criminal charges, that for whatever reason, she's got to proceed with the civil trial before the criminal trial, she should be able to exercise those rights. She should be able to protect herself from criminal liability, and she's done so in this case. This problem has been compounded repeatedly in this case. And opposing counsel could not help themselves but stand up here and rebuttal and take a cheap shot at my client by saying that she didn't really invoke her Fifth Amendment rights. We talked about it in jury selection, but it's okay. You can infer that she's hiding something. She has not carried her burden, even though it's my burden to carry by preponderance standards the evidence for each element.
But it's your burden to prove the contributory negligence. So we have a little bit of a muddle here, don't we, Michael?
Well,
Because
I
maybe
think it's
that's
a
in response to his argument about his co-counsel's argument about contrib.
Yeah, I mean, I get what he's getting at there with the burden shifting, but I just think this is a standalone issue to reference the defendant not testifying as some sort of indication she must be guilty of something, she must be liable. And that is just flat ass wrong. Now, I don't blame him for attempting it. I thought it was pretty blatant that he did. The way he did it was so blatant, referencing the Fifth Amendment and then how she decided not to testify. It was right in your face. And I know we're running late, but I want you to hear what the judge says about it.
Yes.
Not so happy.
I think our chat wants to hear too. Everyone's been here. They're invested. I just see our chat is being invested here.
And so let's see. Here's the response. Hold on. Here's the response, and then you'll hear the back and forth between the judge.
The questions on the jury questionnaire, if you recall, I specifically objected to those at the time of the pretrial motion about the Fifth Amendment. I said that on here unless we know it's going to be invoked. And my memory is that you said, proceed. You're doing this. You're inserting this, as in they are inserting this. If that was never mentioned at all, things might be different. But the issue here is the inference that we're hoping that the jury would conclude is that a Fifth Amendment privilege was exercised, and it wasn't, not even in the absence of the jury.
Right. I agree with you. That's why I don't know why you mentioned it. So I'm going to deny the mistrial, but I am going to grant the limiting instruction. And I find that is appropriate at this time based on the arguments of counsel. So I will pull the one that was offered, and I will send it out for approval as the one that was offered.
So, he's basically, you could tell too from plaintiff's counsel, a little less smooth. I won't say slick, a little less smooth than he had been with his other arguments. Because I think he got his hand caught in the cookie jar, and there's a more grotesque way to say that. But he got his hand caught in the cookie jar, and the judge, you knew he wasn't going to grant the mistrial. You knew that, and so the original instruction offered by the defense was that the classic criminal Fifth Amendment instruction, which says you're to infer nothing from my client, in this case the defendant in a civil case, not taking the stand, and that was rejected during the instruction conference because it's not a criminal case. Well, now, because of what the plaintiff's attorney did, that instruction came back in. In the big scheme of things, I don't know that it makes a big difference. They heard what they heard, and I still think back to the body cam they saw with her sitting on her butt at her desk, not seemingly concerned, to here she is sitting in court on her butt, not seemingly concerned. To me, it's very tough to overcome that visual, to me.
Well, I just think that, with the fact that she did discipline him 2 days ago and he threw the phone across the hallway or threw across the room and broke it, I think that there is plenty of room to say he was after her. He had a motive, and you administration had to do more, and not knowing that he was after her, maybe remove her from the classroom and then talk about the kid, whatever. But to me, I'd find, you're right, I'd find that she deserves money. The problem is that you may start to negotiate with you just to make you happy because you're my partner, or to make you happy next door.
Happen all the time.
Compromise, and then by finding some contrib on her part, not knowing what they do, is going to prevent her from getting money. And then I'm going to throw out the other thing, okay? And I threw it out yesterday. It's for our chat to discuss. This is the R thing, the elephant in the room. You have a plaintiff of a certain, she's white, let's put it, right? Blonde, white, at least when she's here today. You have a defendant who is a minority. Does that cause some kind of conflict with the jury subconsciously? When we talk about being subconsciously biased in some way, we try to train again this unconscious bias. Do you think that there is an unconscious bias in that courtroom against the defendant or against the plaintiff? Because of the racial mix here.
It's legit. It's a concern that you would think during voir dire they hopefully ferreted that out. But I could imagine somebody sitting there thinking this administrator only got that job because she's black. I could see somebody feeling that way, and that she's got, she's down on the teacher because she's white. Sure, people could have those thoughts. Did they get as far as sitting on the panel? Who knows?
I
Who
don't know.
knows?
I don't know. We weren't in the
So
jury
I think
selection.
I think we're only disagreeing on the level of culpability here, the level of liability. I don't.
No, I don't think she had responsibility. I
You
don't think the first grade
zero?
teacher.
Zero?
I think it's zero. I
Wow.
think that when she thinks that teacher is going to the administrator, that they know everything she knows, that they're not coming and doing anything, it's because the administration has decided that he's not a threat, and that she has no duty. She's got to take care of her kids and take care of her stuff. She's a young first grade teacher, and I think the duty here was of the administrator. I think the parents, and the administration is like a parent. The mother went to jail for 4 years. As far as I'm concerned, the administration is the parents, and they had the duty to take control here. All right, this is a 6-year-old child.
I'm not relying on the other folks. If I'm in a boat and the captain of the boat isn't helping when it starts sinking, I'm stepping in to help myself.
I'm not getting a life lesson to abandoning the ship. What are you talking about?
I would get the life jacket and put it on you. I'm not waiting for the captain of the ship to do it.
Oh, that's very
Okay.
nice. You'd
Yes.
be like the person who gave up their
So-
lives in the Titanic and put the women and children first. You are, yeah, but people don't realize you really are such a gentleman. Michel Bryant.
But anyway, we'll see what happens. Here's what I predict. Okay, there will be culpability, liability on behalf of the administrator.
I think you may be right. I think they're going to compromise and do that.
Yep, and then there's going to be a number, and then there's going to be a fight after the fact about we don't know what contributory negligence of the plaintiff did to affect that judgment, and then it's going to be settled. We'll waive our right to appeal, and we'll do that, and whatever the number was, it will become another number, and that's what will be paid. Oh, I know what I forgot. One more thing before we bail
And
out of here.
settled after the criminal case
Yes.
against the present defendant gets resolved, because she has 8 felony charges with her. And quite frankly, if she goes to jail on those 8 felony charges, no wonder the school would want her to want this tried first as opposed to after.
And that's 8 counts, 1 to 5 years per. I got to look into the complaint to see how they come up with 8 counts. But anyway, they don't have insurance per se. They have what's called the Virginia Risk Sharing Association. And this is a group of it's police departments and government officials, teachers. They all put in money into a pot, and that becomes the insurance proceeds.
Yeah,
but it's not a
self-insured,
typical insurance company. Well, I guarantee you a $10, $20, $30 million award is going to be tough for any of these associations. Not that they can't cover it, but it's going to put a big dent.
Yeah,
in
but
their coffers.
they're self-insured. We have that in New Jersey with a lot of municipalities, police departments. They're self-insured. They put into a fund, and they're self-insured for a lot of these shooting
fund
cases.
is insured, which is kind of
right, and then the fund
way
is
to do it.
insured.
And it's an excess coverage, like maybe anything beyond $5 million. Anything up to $5 million, the association might cover. Beyond that, they look at their umbrella type policy to cover the balance. But it's a ding. It's a big number for an organization like that.
And it still gets settled, no matter what happens. This case,
I still think that's what's going to happen. They're going to get this verdict.
Judgment.
I'm going to object as the defense counsel that we don't know whether they found contributory negligence or not. Where's that on the form? And then we're going to fight about it. I'm going to waive my right to appeal, and we're going to cut the judgment in half. Anyway, we'll see. We'll see.
All right.
As far as I
Anyhow,
know,
no
they
one
are
deserves to
still-
be shot. No one deserves to be shot in the chest.
I agree.
To get the job especially by a 6-year-old with a gun, and mama of the 6-year-old is in jail.
Yes, that's right. She is. Or she's finishing up her 4-year stretch. Yeah.
All right.
right, then.
They're still deliberating, Michael. Have we
Well,
checked? Has chat
everything I've seen, Kelsey,
checked and see?
It doesn't tell me anything, so I've kept the clock running at almost 4 hours. Every state is different. We know that Florida will let you go to midnight if you want.
Right.
Others will say, nope, everybody's out of here at 5 o'clock or 4 if you're Bev Canone.
Las Vegas will let you go overnight. They'll let you stay all night.
When I covered OJ and the verdict came in at 11 o'clock that night, we were there. So
you were there, right? That's
all right.
Because
then.
you were always there. You are, as I say, the proverbial Energizer bunny. You will get in your car
this was kind of
everything.
Fun watching this trial. Fun in quotes, because it's just to get so into a case that has so many interesting aspects. I love it, and I wish
And
the
Missy
best for
said
everybody involved.
She said she's
No
checked
verdict.
No verdict, and then
So
so
they've been released.
Yeah. So tomorrow, let's just tell you what we have in store for the rest of this week. On Friday at 6 p.m., we will be premiering your favorite show, a comment show. So, you make the most outrageous comments. You may be in the show, and that would be after, not in the chat, the comments, which are afterwards. And then at 5 o'clock, I'll probably release episode 2 of The Hunt, if I can get my act together with all the things all of you have sent to me to look at, which has been fabulous. Tomorrow night, well, let me tell you about the weekend. We will have a special show on PFAS, Mark Ruffalo's movie
Bless you.
Dark Waters, and and we'll have a special guest, a lawyer from Massachusetts, the wife lawyer of one of our guests who've been on, Michael Del Signore, Tracy Paulson, will be on, and she will be talking about PFAS. What are they? Why they affect you? And I think that we want to try to do some more of that, so that you'll have that for the weekend. That'll be one of our weekend shows. And another one of our weekend shows, what was it, Michael? We were talking about
I think it's the GPS issue
Yes.
with the mass
That's
troopers.
it.
Yeah.
We haven't really discussed that GPS issue that Ted Daniel had that great investigative
Yeah.
story on with that.
You never
and
know what
then-
you're going to get when you do a FOIA request. I mean, I'm sure he
Yeah.
had no clue he was going to get a log that showed Trooper Proctor on a given day was 8 seconds, on the road.
on the not even leaving his driveway. He
Yeah.
wasn't have to leave his driveway. You got the book club with Justin Brooks, and then tomorrow night, what's our show, Michael Bryant?
Well, it'll be interesting. We'll certainly be covering what happens here. I really think
Right.
there will be a verdict in this
Yep.
case. So, we'll explore this a little more and maybe dive into some of the stuff we didn't get to tonight because it was just chock full, these closing arguments for a case.
And an update on Kelsey Fitzsimmons, which we didn't get to tonight. We didn't.
I
have
did,
enough
well, I
time,
forgot
but it
to
wasn't
read
new.
my latest note. I did get a note
Oh,
back
okay.
from Tim Bradle because I
Read
called the
that.
clerk, and the clerk said, "Yeah, we're waiting for the parties to come to some decision." Remember the order said that they want to try to do it expedited, but Commonwealth and counsel for Ms. Fitzsimmons need to get together on a schedule. So the clerk's waiting for them. Timothy Bradle said he's waiting to hear back from the DA. So that's where
Aha,
that is.
that doesn't surprise me at all. So
No,
maybe
they're
we'll
dragging
have,
their feet, because what do
Yeah.
they care?
yeah,
we
more
know they
of an
don't care.
update.
We've
Yep,
seen
we
it.
know they don't care. We know they don't care about Kelsey Fitzsimmons. They just care about protecting their thing that they sit upon.
Yep.
And
Robes
maybe the
protecting
judge,
robes.
and maybe
Could
robes
be.
protecting robes. That was a great comment. Okay.
All right,
All
then. Thanks, partner. Let's do it again tomorrow. I'm Michael Bryant.
I'm Linda Kenney Baden.
Yeah.
Yeah.
This is Just to Serve TV. Try to do the right